So that's how we're starting our conversation on the First Amendment. I want to welcome our guest now, and I'm going to start with Stephen Waldman, who I'm so glad is with us today. Stephen is so respected in the world of journalism, and he is very germane to this conversation because he is the president and co-founder of Report for America. That's a national service program that places emerging journalists into local newsrooms. Previously, he was senior advisor to the chairman of the FCC, and he served out of the Office of Strategic Planning, and literally hot off the presses. His brand new book is called Sacred Liberty, America's Long, Bloody, and Ongoing Struggle for Religious Freedom, just won the prestigious Wilbur Award for the best faith-related book. Congratulations, Stephen. We're so happy for you. If I can now, a little bit more formal introduction to Uzma. Uzma, by the way, is a lawyer. She is a scholar. She specializes in U.S. and international religious freedom. That's why she was working with the Beckett Fund, by the way. She also writes and speaks on American Muslims and gender. She writes about Islam and religious freedom, and her new book, which is doing marvelously, is called When Islam is Not a Religion, Inside America's Fight for Religious Freedom. So congratulations on your book as well. Last but certainly not least, the gentleman to my far left, which is the only time he will be to my far left. He happens to be working as the General Counsel for the National Religious Broadcasters and founding director of the John Milton Project for Digital Free Speech, also serves as special counsel for the American Center for Law and Justice, and his latest book is called The Empowered, which is not the story of our marriage, but I digress. It's a different story. So let me...
Am I to remain silent and no rebuttal to that one?
Here's where your First Amendment rights don't apply. All right, let me start out. Justice Alito has said that the First Amendment is the jewel of our Constitution. What a great thought. And so I want to start out by taking a look, if I can, at just some cases that are out there, a myriad, a panoply of cases on all different topics. But we've got two lawyers and two non-lawyers up here. And there really is a kind of cultural application to a lot of these legal cases as well. But they exemplify why the First Amendment is beautiful, it's important, it's precious. You just heard the general beautifully illustrate that. But it's also problematic because you realize these few words can be so misinterpreted and misapplied. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. That's it. That's the totality of the First Amendment. And as a result of that, we have centuries now of what we've been talking about. That's what Stephen writes about in his book, by the way. So let me just take a look as an example, as a launching pad. And I want to go to Brevard County, Florida. There is supposedly there now a violation of the Establishment Clause of the First Amendment in Brevard County. This was a place in Florida where the old policy had representatives from various religions who could come and pray or offer a moment of silence. Brevard County adopted a policy back in 2015 that precluded secular invocations from being offered at the Board of Commissioners meeting because the policy stated you could have members of our faith community appeal for guidance for the county commissioner from the highest spiritual authority, a higher authority which is a substantial body of Brevard constituents believe to exist. So in other words, they presuppose the existence of a deity that would be tied into the invocation. So 5 individuals who identified themselves as atheists then turned around, they sued the board, and they called themselves humanists. So there were challenges from the Central Florida Free Thought Community, Americans United for Separation of Church and State, ACLU, Freedom from Religion Foundation, Humanist Community, and the list goes on. So the 11th Circuit takes this case up, and they said that the policy, in their opinion, did in fact violate the U.S. Constitution's clause, the Establishment Clause, in a 3-0 decision. And in part, their decision said this: Brevard County has selected innovation speakers in a way that favors certain monotheistic religions and categorically excludes from consideration other religions solely based on their belief system. Brevard County's process of selecting invocation speakers thus runs afoul of the Establishment Clause. So they also wrote this: from their testimony, it's abundantly clear that most, if not all, of the commissioners exercise their discretion in a way that discriminates among religions based on their belief, favoring some, but not all, monotheistic and familiar religion sects over those faiths that fall outside the mainstream. The result? The county's facing a $490,000 fine, $60,000 in compensatory damages, $430,000 in attorney's fees, which is why Shakespeare said, let's kill all the lawyers, but I digress. So Craig, let me turn to you if I can. He's wearing cufflinks right now that say, let's kill all the lawyers,
Let's
by the
kill
way.
all the lawyers, right.
So the first question to you, Craig, is this. It was a 3-0 decision. Anybody can look at that and say that's a pretty unanimous decision. Do you think they decided the case rightly?
No, absolutely wrong. By the way, I am wearing cufflinks that say, let us kill all the lawyers. But that was a bad guy who said that in Shakespeare, by the way. He wasn't a hero. Shakespeare believed in the value of lawyers. But let me address this. You need to know the black story. You need to know the program before you can follow the game. This lawsuit was brought by the Free Thinkers Society, a group of atheists, also the Freedom From Religion Foundation, a group well known. I argued against them in a state Supreme Court case years ago. They are hardened atheists. What they really want is special protection for atheism on the same level as religion. Now, unfortunately, for them, the founders didn't agree with that. But that's what their motivation was, and it's clear because I've read their literature. Now, the court sidestepped, fascinatingly, that issue. They didn't decide the issue, is atheism protected the same way religion is? What they said was, well, the way in which you've enforced your policy of prayer was improper. You really favored God-centric and Christian orthodoxy in the people in which you allowed to volunteer. Now, I could go into the nuances of the law. I'm not going to do that. Supreme Court decided a case called the Greece, New York case, and I think that case, if this goes up to the Supreme Court, they're going to get overturned. But let me go to the broader issue. Broader issue is atheism is not entitled to the same type of protection. This is an agenda. I've seen it in briefs and in court cases for the last decade. To have special protection for atheism on the same level as religion. The reason I say that is because I believe in the original intent of the First Amendment. John Adams in 1813 wrote a letter to Thomas Jefferson. They were both out of public life at the time. And he said, looking back on the Revolution, what was the cement, what was the glue that brought us together, all these patriots who suffered the loss economically and sometimes their lives and their fortunes and their sacred honor for the creation of this republic? He said 2 principles were common to all those who fought in the Revolutionary War on the side of the colonies. Number 1, he said, the principles of English and American liberty. Number 2, the general principles of Christianity. Now, I am not saying we have a theocracy at work, but I'm saying the background of the First Amendment was, in fact, in that letter, Adams even lists the Christian denominations that were representative of not only those in the Continental Army, but also those who were in the First Continental Congress. So what I think he was saying is the general principles mean we don't have a theocratic oath in this country, but we do have an understanding that we are a people who believe in a God. And we are informed by the Bible at that time in terms of our understanding of the frailty of human nature, as Attorney General Barr just said, and the fact that there is a God who governs the futures and the histories of nations, as Patrick Henry said. So with that understanding, atheism is to be protected on a free speech basis. But if you have invocations, religious invocations, atheists will have to wait, as the Brevard County said, wait for the public comment section to view their opinions and not interfere in the religious invocation section. And that is a very logical distinction, I think, that the court got wrong.
Usmel, do you agree or disagree with his assessment?
Well, I think, well, first of all, thank you. Thank you, Janet, and thank you to NRB for having me here and for welcoming me even after everything that happened. And I have to say, I share the belief. I mean, my work at the Beckett Fund and throughout my entire career for the past decade working on behalf of religious freedom has absolutely come from a place of respecting and honoring the space of religion in the public space. I absolutely agree with Attorney General Barr that religion serves a vital function and that it is important for all of us to maintain that space for religion, but I would say also a diversity of religions. And so I think with respect to this distinction between atheists and non-atheists or atheists and Christians, I mean, the Town of Greece Supreme Court case specifically said in that context that it was constitutional to open legislative sessions with prayer, but that space had to be given to a variety of different views, and I believe including groups such as Wiccans, people we might think of as non-theistic. And so I think that religion is important, but it's absolutely essential to protect religion in terms of its most diverse forms.
Stephen, goes to you because you're really into the history, and he was quoting a lot of those founding fathers. Give me your take on this.
Well, I tend to think that any sentence that begins, the founding fathers believe, is untrue. Like you can just assume it's untrue because the founding fathers disagreed with each other on issues just like this. And you had this wonderful kind of perfect laboratory experiment where 4 of the people who were so instrumental in birthing religious freedom then got to be president and actually say what they try to implement. What does religious freedom mean? And it turns out they disagreed with each other then too. So you had President Washington and President Adams issuing prayer proclamations from the White House. Obviously had no problem with the idea of a government official invoking God or having a clear message of religious purpose. And Jefferson and Madison were furious. And they opposed what Adams and Washington did with their prayer proclamations. Now, what's interesting, perhaps in this gathering, is that Madison and Jefferson's allies were the evangelical Christians of the 18th century. The evangelical Christians of the 18th century who were religious minorities, persecuted minorities, the Baptists in Virginia, for instance, were the staunch allies of Jefferson and Madison. And their view on this was that even well-intentioned efforts to help religion would backfire. And that's why they were really more separatist than Washington and Adams were. And I feel like, I often say that I think to me the most interesting debate right now would be not so much a debate between 21st century Christians and 21st century atheists, but a debate between 21st century Christians and 18th century Christians on the perception of what does the First Amendment mean. And I think that it's their view, and as is the modern Christian view, was very biblically based. And it is absolutely true that they agreed with Attorney General Barr, they would have if they were here, that religion is the foundation for a healthy republic. They just thought that the way you achieve that religious dynamism and vibrancy is to get government out of the way. And so I tend to think of some of these cases are kind of in this category that I would call constitutional but rude. I think that probably was constitutional, whether it's
but not very nice, right?
Whether it's wise or
Yeah.
The right way to knit together a community is a little bit of a different question. But it always, it's always puzzled me a little bit that conservatives who appropriately have a trenchant critique about how government messes everything up seem to be fine with government writing prayers. Which seems like the last thing you'd want government to be involved in doing.
So as a follow-up to that, so there's this delicate balance. How does government then, because they're not called to be hostile towards religion, clearly history tells us it was about the prohibition of establishing a national religion. They saw that in England. They didn't want it here in the United States. But how do we have the recognition or the acknowledgement of the role that religion plays? So for example, we have these invocations. Let me take it to Washington. We have chaplain in the House, we have a chaplain in the Senate. We begin each sessions with prayer in both houses. How much of that constitutes the breathability of the liberty of religion as opposed to having it being grotesquely misinterpreted as the establishment of religion?
This may be the only time I've ever said this, but I think Congress actually kind of gets it right. I'm not sure that sentence has ever been uttered from these stations, but in the sense that they do open their sessions with prayers, and they do have clergy come, but they approach it pluralistically. They don't have a single denomination, and they allow clergy. And I actually think that's a pretty good model for the rest of the country.
You agree?
Well, I think most lawyers, for us on the lawyer side of this, would agree that the establishment jurisprudence in this country is essentially a hot mess. There's been a number of different tests that have been proposed by the court. You have the Lemon test, and you have the endorsement test, et cetera. A lot of them sort of are subjective. What would the subjective, sort of hypothetical, make-believe, reasonable observer think when they see these various sort of proclamations of religion? And so a new approach, one that seems to be succeeding, there was a recent case at the Supreme Court involving a 40-foot cross, Latin cross, in Bladensburg, Maryland, which the court upheld, saying it's been around for a long time. It serves it's a part of our history. It serves a secular function as serving as a commemoration of the sacrifices of the veterans of World War I. And what does it mean when if you were to go around sort of like obliterating all these religious symbols in the public space,
Right.
what does that have to do with then, how do we reconcile that with the free exercise clause?
Yeah.
And what it tells us in terms of protecting religion? And so an approach that's being advocated among various people, including Michael McConnell, the former federal circuit judge and now professor at Stanford, and the Beckett Fund, is to have a clearer approach to the Establishment Clause. Say, let's go back to the founders. Let's see what were they thinking about when they decided to disestablish, right? When they enacted the Establishment Clause, what was it exactly that they were thinking about? And so some of the things that the founders were thinking about were things like, well, we don't want the government to step in and pay for clergy, to have any role in choosing clergy, or to cede power to religious bodies to engage in government functions, et cetera. And so these advocates have essentially broken down these sort of set categories, and they're like, here's a clear idea of how to manage the Establishment Clause. Just go to the issue that's being contested and see, does it fit one of these categories? And if it doesn't, then it's constitutional.
Janet, you ask a good question. In fact, Ozma and I both know when you're in front of a court, particularly a higher court, a court of appeals, those judges or justices, what they really want from you is a good legal test. Give me the test that we can apply that solves this case and future cases like it in a way that's consistent with the Constitution. Well, I'm going to give you my test. And it's really not mine because it belongs to some of those like James Madison, who were the architects. If you look at the annals of Congress, and by the way, I have more confidence in my historical research on this than perhaps you do, Steve. And I've heard the argument before. Well, really, no one really understands what the history is. There's no consistent thread. I think there is. Here's the test. It's called the coercion test. It's real clear to me as I looked at the debates about the actual language of the First Amendment with regard to the religion clauses. Their concern was that the government would not coerce people to do or say or perform acts in violation of their religious conscience. It was the coercion test. The Supreme Court took that and extended to the point of, I think, absurdity in the Lee versus Weissman case in a graduation ceremony where a rabbi gave a very innocuous prayer, and Justice Kennedy, who got it wrong, I think, in that case, said people were sort of implicitly coerced to respectfully, bow their heads during the prayer and so forth. And I think Scalia got it right. Have a psychological test like that of coercion is ridiculous. We know what coercion is. Forcing someone in any objective way to do or say something that violates their religious conscience. And the Greece case, where in the village of Greece up in New York, where they had prayers that were predominantly Christian, Supreme Court said, the community is primarily Christian. You didn't show evidence that they were selectively trying to have just Christians. It's just that's all they had in the community. And people weren't coerced by the prayer. I think that's a good test. Isn't it, Steve?
I think it's a good starting point, but it's not sufficient.
Not an ending point, right?
Yeah, no, I think that the founders, I'm now about to violate my rule, the founders, especially Madison, let's just put it that way, and he had something to do
Who,
with
by the way, issued religious proclamations when he was president.
and then said he felt very bad
Okay,
about it.
afterwards, okay. All right.
They also believed that the government shouldn't favor one religion over another, whether it was coercive or not. And in addition to that, and this is where there really was a very stark difference between different founders, was on the question of what about well-intentioned efforts of government to help religion in an assertive way? And there really was there was a real difference. And Madison was actually kind of a hardline separatist on this point. And his allies in this case, as I said before, were the Baptists of Virginia. And there was this really interesting fight before the First Amendment in Virginia over a bill that Patrick Henry had endorsed that was a very broad, pluralistic bill that said, we're going to tax you, and we're going to use the money to pay for clergy and religious teachers. And we're not going to force you, we're not going to say it only goes to the Anglican church. You can give it to whatever church you want to. So in that sense, it was very modern. And Madison was appalled by this. And Madison, working with the evangelicals who had just spent the previous 10 years being imprisoned in Virginia for the crime of preaching the gospel. I mean, incredible stories, by the way, if you don't know this. I mean, this Baptist preachers in down the road from Madison's house, speaking from the pulpit, and the guy from the Anglican church is coming up, sticking a bullwhip in his mouth, dragging him out and beating him up. And this was something like half of the Baptist preachers in Virginia were imprisoned by the time of the American Revolution. They became Madison's biggest allies on this. And his point and their point was that you may think that efforts to help, like this bill, sure, are going to actually, be good for religion. If you like religion, as we all do, why not have the government help it? It's going to backfire, he said, because when the government gets involved, even in a well-intentioned way, it is going to start to distort the way that people make religious decisions. So it wasn't even just about coercion. He actually thought religion would get lazy. This was the argument that that John Leland and some of the ministers of that time were making, is that it wasn't just about coercion. He said, this is going to be bad for religion, that what we really need is a kind of marketplace. And it shouldn't have government money supporting one religion over another. It should be really an open, fair marketplace. And the Christians of that time were very self-confident Christians. And they said, the power of Christ's message will do just fine if we just let it be free instead of having the government try to help it.
So let me pick up on, Asma, you say things, then
so
I'm
I
going to throw in
absolutely
another
agree
element.
with what Steve's saying in terms of the founder's vision of disestablishment, the fact that ultimately it was better for religion. And in fact, it does. I mean, the more you keep government out of religion, the more space it has to grow and to flourish. But I think the other problem I have with this coercion test, I mean, Craig said, we know what coercion is. But do we? And especially, I think, with changing sort of notions of offensiveness and the coercive element of offensiveness, I think that absolutely, if there's any time in American history, it's now to say that we don't know what coercion is. I think everybody has very different standards. If somebody is offended by something, is that because they're being coerced by it? And in fact, there is this thing called offended observer status, where a number of these atheist groups, Freedom from Religion, and others say that, oh, well, we saw a statue of Jesus on public property, or we saw a monument with the Ten Commandments, and we were offended by it. And the court actually currently allows them to bring suits simply on the basis of the fact that they were offended by it.
Wow.
Well,
So let me throw something else.
Well,
Wait,
well,
before,
it-
no,
but-
wait.
but
Let me
Asma,
throw something else in.
the coercion test that you've said is too nebulous. All of these tests are going to be nebulous until they're defined. The point is, can coercion be tested and defined the way the Supreme Court, or at least the founders, articulated it? And I think that it can. Can it be logically, not perfectly, but logically applied to say everyone must bow their head and pray? That's coercion. We're now going to pray, and if you want to bow your head and join us, that's not coercion.
So let me throw this in a different way. Let me take it from the Congress to the classroom. On National Religious Freedom Day, I bet you didn't even know we had one of those, last month, the president invited Christians, Muslims, and Jews to the White House, and he signed a directive that was going to be worked through the Department of Education that basically said, we're going to pull your federal funding if you do anything to prohibit the religious expression of students. And then during the course of that meeting in the Oval Office, he heard from Christians and Muslims and Jews, each of whom gave testimony to what it was like when their religious expression was in fact mitigated, censored, silenced. They weren't allowed to do it. So the threat from the federal government is to the school administrators, and after this meeting in the Oval Office, all 50 states, the state directors of ed, each got these letters saying, we're going to pull your fund, and we're going to track this to make sure that you haven't prohibited the religious free speech. And during the course of the meeting, the president said, government must never stand between the people and God. So there's an interesting intersection here. So it isn't about the establishment, and we're trying to talk about the neutrality that the government must maintain without showing due deference to any particular religion. But how does the government walk that line that they don't and mustn't cross, where they practice silence under the guise of trying to maintain unanimity among all religions? First of all, Asma, let me ask you, do you think that the president signing this directive through DOE was a good idea?
I absolutely think it was a good idea, but one thing that has to be noted is that that guidance was actually first put together after extensive work by the Clinton administration, then it was updated by the George W. Bush administration, And what President Trump was simply doing was saying, look, we're going to enforce this guidance. So I think a lot of people think that Trump sort of came up with it, but in fact, President Bill Clinton was actually the one who originally put together all the guidance that was then reissued and updated
But not enforced.
by President Trump, which
Yeah.
is an important point because it kind of shows the importance of religion to both parties, right? It's a nonpartisan issue, this idea of protecting religion and religious freedom. And I think that's so essential even to the way that we continue to defend it in this country. The more we keep making it a partisan issue, the less likely it is to resonate with people and to continue to sort of have a robust and vibrant space in our country.
Stephen, you think it's a good idea?
Yeah, when I read that, prior to this most recent thing, but the guidance that Asma is talking about, I was surprised at how much consensus there was, because we spend so much time talking about the controversial parts and the debates. There's actually, over the last 30 years, has been a fair amount of consensus that is developed that allows for a lot of room for religion in public schools. Now, one of the things that happens is it gets politicized, but there's also a lot of ignorance on the school and teacher level about it. There was an amazing study that I came across when I was doing my book where a PhD student did a whole bunch of different hypotheticals to high school teachers of different church-state issues. And they got them wrong about 70% of the time. And by the way, it cut both ways. Sometimes they got it wrong being too restrictive, sometimes they got it wrong being not restrictive enough, but mostly they just were very ill-informed about what it was. And so that on the Department of Education level, there is a surprising amount of consensus, not unanimity, but there's an awful lot of room for religion in the public schools now.
So let me pick up on something we heard from the Secretary of Education this morning. We're talking about real freedom in education. And there is a particularly interesting debate going on in Washington now about not showing due deference when it comes to scholarship funding. So if we're going to say, and by the way, you go back to the GI Bill shortly after World War II, there were all kinds of men who became pastors because the voucher was given to the individual soldier, sailor, Marine, who then applied it to the school of his choice, therefore circumnavigating the church-state entanglement issue. But now the idea is, and we heard it during the State of the Union address, that those scholarship dollars should be used for parents to make the choice of the school of their choice. Some would argue, oh, church-state entanglement. You've got government funds vis-a-vis these scholarship dollars that are going to a religious school. Cannot have that. Craig, I'll start with you. Is this a good idea or a bad idea?
Well, first of all, I've been a great supporter, and frankly, the Supreme Court has too. So I take their lead from them in supporting all varieties, almost all varieties, not all their cases, but most varieties of a voucher system in terms of school choice. In other words, the court says, look, if the decision maker, and this is the key, if the decision maker is the family or the citizen or the taxpayer, then it's constitutional. If the government's making the choice of preference for a Christian school or a Catholic school, then you've got an Establishment Clause problem. But there are bigger and I think more troubling cases on the line, and I know that we don't want to get off on cases that we really haven't thought about before coming here, but the Supreme Court just took certiorari on a case coming out of the Third Circuit with a Catholic social services agency, adoption agency, that was told you must place children in same-sex families or same-sex relationships if the opportunity arises. And the Catholic Social Services, which has done business for 100 years in that state, New Jersey, said, no, we can't do it, it's a violation. Now, the Catholic Social Services argued, we need accommodation. The court wrongly said, no, this isn't an accommodation case. You don't need to be accommodated if we're providing a benefit. That you can see the dividing point, the nuance between when accommodation is required, like let's say an employment situation with an employee who wants to wear a yarmulke if you're a Jewish employee and so forth, and getting support from the state in terms of being able to be part of the public funding of those agencies. I think that's an artificial distinction. I think, frankly, that we need whole families, children protected, and children placed in homes that have the same kind of religious background as the birth parents would have had, and the best interest of the child would say, rather than be politically correct, and let's put kids with an equal basis into gay homes as we do in heterosexual homes, I think that we ought to encourage the diversity of organizations that help the public good. That means Catholic Social Services, the Protestant social service agencies, and ones that are entirely secular. And I think this case is going to be a seminal one because it's going to tell us, it's going to be a barometer, I think, on how far we've gone towards secularism or whether we are still respecting the fact that religious organizations, that faith-based ones, including Christian ones, should be able to participate in federal funding in this situation for child welfare, along with secular ones.
Well, I just wanted to add first on the voucher issue. I mean, one of the cases, set of cases that I used to work at the Beckett Fund involved the so-called Blaine amendments. So these amendments are a part of various state constitutions that were a product of 19th century strong anti-Catholic animus. It was named after James Blaine, who advocated this, and he was a part of the Know Nothing Party, right? The ones who was a nativist who sort of rallied against Catholics. And specifically, these measures were aimed at limiting the impact or influence of Catholics on public education, right? The idea was that that sort of influence was a problem for America, and that it would instill in children the wrong values, anti-democratic, anti-American values. Which is interesting because, of course, that sort of idea and fear-mongering, unfortunately, is leveled, it continues to be leveled, not against Catholics, but against my own religious community now. But when, so many years later, we continue to see the effects of that. On this question of the adoption agency case, I agree. I think that it's absolutely a signal of like major sort of what happens. It's going to tell us what's going to happen with a number of other sort of reckonings between religion and other values and rights that are being negotiated alongside it, right? Right now we often hear about this as religion versus non-discrimination, which is another way of saying religion versus LGBT rights. And I think that to understand the full scope of what's at issue now, we have to think about the government, right? Just the government being involved pretty much everywhere and giving out billions, if not trillions, in benefits, the licenses and permits that it gives out, and the fact that as we begin to allow it to distinguish who gets these benefits and who doesn't, who gets the mere sort of privilege of existing and functioning in our country based on what their beliefs are, then I think that definitely there's a big problem that awaits us.
So let me stay in the world of education and go back to the Oval Office again. Only this time, December 19th, the president signs an EO, an executive order, this time dealing with anti-Semitism. Now, I would like to believe to the marrow of my bones, every single person in this room would speak out against any form of anti-Semitism, anywhere, anytime. But the question is remedy here. And since we're talking about the cherished nature of the First Amendment, he signs this EO that basically says where and how the administration defines anti-Semitism. And it says this: the non-legally binding working definition of anti-Semitism adopted May 26, 2016 by the International Holocaust Remembrance Alliance, the IHRA, states, anti-Semitism is a certain perception of Jews which may be expressed as hatred towards Jews, rhetorical and physical manifestations of anti-Semitism directed toward Jewish or non-Jewish individuals and or their property, toward Jewish community institutions and religious facilities. Seems pretty straightforward. And then you have an event at the University of North Carolina. And they have a conference entitled Conflict Over Gaza, People, Politics, and Possibilities. And during the conference, there was a Palestinian rapper who performed what he called an anti-Semitic song. And during the course of the song, he starts singing, "I'm in love with a Jew," and then he said that he cannot be the only anti-Semite in the room. Join along and sing with me. And he's confronted with this video. The UNC sees the video, and they said, you misconstrued what this conference was all about, so they basically crawled under a rock. Well, the bottom line is there are specific examples that they pulled from IHRA to define anti-Semitism. Not only do you have this EO, now you have the definition of what constitutes anti-Semitism, and they include, and they took this from IHRA, protected political speech such as the drawing comparisons of contemporary Israeli policy to that of Nazis, denying the Jewish people their right to self-determination by claiming that the existence of the State of Israel is a racist endeavor. We could go on and on and on. So here's the conundrum. We abhor anti-Semitism. Is the remedy here the government, again, with the threat of withholding funds if we see these atrocities on college campuses? We recognize the reality of the problem. Is this cure worse than the disease?
Well, I think, the irony here is that I think politically, conservatives for the last decade, I believe, have gained the moral high ground when it comes to free speech on campuses. That it's been the left that has been attacked, and for the most part, free speech on college campuses in a bit of a historical reversal. And I think that in one fell swoop, Trump forfeited the moral high ground that conservatives had earned and built up over the last 10 years on it for exactly that reason. It's basically responding with a technique that is the mirror image of what the left has been doing on college campuses, of over-defining hate speech, in effect, in this case, anti-Semitism. I should say, the goal of this and the shining the spotlight on this problem is very positive and very important. I mean, it is anti-Semitism on campuses is out of control, and so to make a big deal of it, I really commend the president for doing that. But the definitions that they've come up with, as you indicated, for what that is, really put the government so deep into defining speech. Like if I got up on a college campus and said what Jimmy Carter, the former president, said in his book called Apartheid, where he argued that Israeli policy was akin to apartheid,
Right.
that probably violates this definition. So the university would lose funding if they allowed President Carter to speak on his book. I mean, that seems like this is way overboard in terms of how prescriptive and defined they've gotten, even though I respect the motives.
Craig.
Yeah, I think that's probably an area that Stephen, you and Ozma and I probably have complete agreement on. And that is, we don't like hate speech, but we know it can't be made illegal, because the consequences of that will come back to haunt us, every one of us, in terms of our position. I know it's been used by Silicon Valley as an excuse to shut down Christian viewpoints on Google and Facebook and Twitter, rhetoric that is nowhere near what you and I would consider to be hate speech. It's interesting, under the Clinton administration, the National Telecommunications and Information Agency, one I didn't even know existed, by the way, NTIA, I discovered it a couple of years ago, was actually tasked to define hate speech. And they spent quite a bit of time and money looking into it. And the idea then, and this is back in the 90s, so we didn't have the internet influence like we do now, but they were asking this question: is hate speech over the radio and television something that could ignite hate crimes? That is to say, crimes of violence. And the study came out, number one, saying we don't see any connection between broadcast hate speech, so-called, and hate crimes in terms of violence against protected minorities and so forth. But then they said, second of all, they had a hard time defining hate speech. So the best they could come up with, this federal agency that spent all kinds of money and all kinds of time, said hate speech is anything that engenders hate against certain groups. So really, if they couldn't define it then, Silicon Valley, Facebook and their rules, their community standards, haven't been able to define it. And I think the Supreme Court's made it pretty clear hate speech is regrettably going to have to be protected, because the price of free speech is that you're going to hear some of this grotesque stuff that you don't agree with and don't like.
I wanted to ask Ozma something about
You may.
this. May I? One of the other parts of this order was that the way that they were trying to implement this was, instead of saying what I think would have been the right approach, to say that Title VI prevents discrimination on the basis of religion,
Right.
They didn't do that. They said Judaism is a nationality. They said it already protects on the basis of nationality, so we're going to say Judaism is a nationality, and therefore you can't attack Judaism. Well, this is like a very fraught area. Jews have been debating amongst themselves for centuries about whether they're a nationality or a religion or both or which, but it relates very much. It really triggered something for me to use with a phrase the college students use. This notion of whether something is a religion or not. Now, this is the title of Ozma's really superb book, and I'm curious, kind of whether that, what that stimulated for you.
Sure. So on the one hand, I get it. On the other hand, I have the same concerns that you do. So Title VI only protects against discrimination on the basis of race, color, or national origin. So the idea was, by saying that that Jews get protection under this national origin provision, what they were trying to get at is this idea that when there's a conflation of Judaism and Zionism, or this idea that individual Jews on campus have to pay for the wrongdoings of the state of Israel. So understanding that there was this sort of rampant tendency to conflate the two, that's what it's trying to get at. What was interesting is how many people in the Jewish community received the executive order, saying, well, they worry that the administration oftentimes sort of sends the message that Jews are not fully American, right? That there's some sort of dual loyalty issue there. And they're like, well, what's going to happen now with this executive order that's once again calling into question our Americanness and setting us apart, and by saying that we have a different national origin, right? A different ethnicity, something that's not American. And that's a concern, yeah, that I absolutely have. The title of my book is When Islam is Not a Religion. And it's based on this claim that I actually heard while I was litigating a case in Murfreesboro, Tennessee, that Islam is not a religion. It is instead something else. And in the case of that argument, it's a dangerous political ideology, and therefore Muslims don't get any rights under the First Amendment. And this argument was being used to stop a mosque from constructing a building, right, to actually constructing a facility for Muslims to worship in. And unfortunately, that was back in 2010. The US Department of Justice had to step in and file an amicus brief, believe it or not, in a chancery court in Tennessee, explaining that Islam in the United States is considered a religion. And at the time, I thought it was a pretty fringe argument, but unfortunately, since then, it's something that's come to the fore, including current advisors to the president are making this claim. And I really wrote this book from the perspective of like, well, what does this mean for all Americans? The second you allow the government to distinguish between the beliefs that it likes, the beliefs that it wants to protect, and the ones that it doesn't like and doesn't want to protect, hey, that's going to come back to bite us all. And I think just a really important point that I wanted to make, especially given some of the statements that were made about me earlier, which I just completely did not expect, and that's the first time it's ever happened to me, is because I always come from a place of consistency and integrity and say when I'm advocating for religion, it's not special interest pleading. It is to protect it for everyone, because honestly, it's the only way that we're going to protect religious freedom. And when I say religious freedom for all, I don't by any means say that it's supposed to be a free-for-all. There's absolutely limits on religious freedom. If something is getting in the way of someone's physical security or national security or safety or health, then the government very much rightfully can step in and stop someone's religious practice. But what's being advocated, unfortunately, in some very powerful spaces, is something not that. It's simply the ability to engage in sort of bread and butter religious exercise, such as the building houses of worship. And that's something that I think is really worrying.
Can I pick up on that for a minute? And that is that really is the thesis of this conversation. If I were to give it a working title, I would call it The Blessings and Burdens of the First Amendment. So while we have the religious diversity is a hallmark of this nation, it always has been. We heard the Attorney General talking about the rights of conscience. We heard Secretary DeVos talking about the rights of conscience. That is a very cornerstone definer of who we are as a nation, and we have a rich, long history of defending rights of conscience in this country, and may we always do that. So it really does raise this interesting question about recognizing that part of the difficulty is you have your sincerely held religious beliefs. But because of the First Amendment, under the paradigm of the country in which we live, it gives everybody a right to set up their booth in the marketplace of ideas. You don't have to agree with them, but when you deny religious liberty to one group, do you not set up a paradigm to then start denying religious liberties to other groups, and you do so at your own peril?
Janet, can I make one comment before we go into the even playing field issue, because that's hugely important. The courts have always been reluctant to determine the value of any religion. This is a good religion, this is a bad religion. They've also been reluctant, but have had to in the past, determine what is a religion and what isn't a religion. And there is case law that says, and determinations by the Internal Revenue Service, that neo-Nazi groups or white supremacist groups that hide under the banner of Christianity are really, in effect, political organizations rather than religious organizations. Right. Likewise, there are jihadists who can use Islam for political reasons and will have to be treated as political groups without religious protection. Courts will have to make those distinctions. They will not be easy, but I think if we don't make that distinction, we've made religion such an all-encompassing category that the atheist will say, I have a religion unto myself because I worship myself.
We're almost out of time because things went a little longer this afternoon, but I want to give you each a chance to wrap up. And by the way, you realize we're just barely scratching the surface here. You can imagine how much more deep we could go with each of these questions. So let me just ask each of you to give 30 seconds as a closing thought. As we look forward to the future, how well preserved is our First Amendment? Where are our greatest risks? Stephen, let me start with you.
Well, you know, the premise of my book, Sacred Liberty, is that religious freedom is America's greatest invention. And by the way, that there's probably no group that has done more to define and advance religious freedom in American history than evangelical Christians, especially in the 18th and 19th centuries. I think there's a lot of potential threats to religious freedom now. I think that the thing that disappoints me most, to be totally honest, is that Christians really face a number of challenges and threats on this front. And at exactly the moment that Christians need to be respected and heard on this, they have forfeited their credibility in many cases by attacking Muslims. And that one of the biggest, and Frank Gaffney was Exhibit A. Frank Gaffney's position on Islam is that it is not a religion, and that most mosques and people in mosques in America should not be allowed to hold office or have the rights of the First Amendment. And it's an extreme view, but I would love to see in the next 10 years for Christians to reclaim the mantle of leadership that they had in the 19th century and 18th century in defining and defending a real religious freedom, which is to say not only the religious freedom problems that affect Christians, but also the religious freedom problems that affect other religions. And you are in a unique position to make that happen. And if that happens, I'm very optimistic.
Stephen, thank you for that. Uzma, your thoughts?
Yeah, so I come from a very global perspective because I started off my field, my work in the religious liberty field, working on international religious freedom. I was part of the legal team in Indonesia, for example, that was litigating against the blasphemy law there. And I've also worked on the blasphemy laws in Pakistan, for instance. And so in comparison, like when I sort of compare the US to what's going on abroad, the US absolutely has always been, and continues to stand out as just sort of the most vibrant protector of religious freedom. I mean, we have unparalleled rights here. That said, I do think absolutely that there are very real problems facing not just Christians, not just Muslims. It's not just a question about majorities and minorities. All my work comes from a place of saying we have to depoliticize this. We have to stop making this about the particular beliefs and whether or not we agree with them, and we have to come at it from a place, again, of consistency and integrity, because quite frankly, not only is that the right thing to do, but it's honestly the only thing that we can do to protect the future of religious freedom.
Thank you, Uzma. Craig?
I've spent a lot of time, just like Ozma has, in terms of religious freedom cases around the country. And I have to tell you that I have more faith in the most liberal judge out there in a federal court, and I've been in front of several of them, or even very liberal state Supreme Courts, particularly in the Northeast, and I won't name any more than that. And yet have come out with a recognition from their decisions that they recognize what religious liberty is all about. I have more faith. I think that the secular courts get it right about 70 to 80%, while our cultural institutions get it wrong 70 to 80%. I mean the world of academics. I mean Silicon Valley technology companies that control the internet. I mean, frankly, the mainstream press. Interestingly, the Washington Post, a study showed that over the last decade, they've increased their coverage on religious liberty issues by 10 times, but they're still getting it wrong. So I have more faith in the courts than I do in these cultural institutions because I believe that their positions are hardened against particular views. I believe if you take the word evangelical and put it in a Google search, you're going to find 90% negative, 10% positive in terms of the treatment by the press and the treatment by Silicon Valley. So that's where I think the challenges are coming.
Well, I want to thank all three of you because you've done nothing but whet our appetite to hear more and to learn more. But I hope that we have accomplished the goal of at least serving up some food for thought. Would you thank our esteemed panel, please? Thank you so much. And you are dismissed. Thank you.